Caesar's sister in 1A tried to translate it for us, but she said it was more her husband's language than hers, and he translated it, and they wrote it out for us, and that was very nice. And I invited her to go to church with us, and she said no. And at church, several people had received Francisco's letter, but they could not read it either, so they were glad to have it translated. 12/25/94 Christmas. It was our 40th wedding anniversary. We were married in Wellesley Hills outside of Boston, Massachusetts on Christmas Day 1954 at the First Congregational Church by the Reverend John Wallace. At 6 a.m., washers and dryers are a pleasure. Roberta left litter in the cellar, another white plastic bag, and the hall and the cellar have not been cleaned at 7 a.m. Christmas morning. So I took the rubbish out of the big trash bag and I put it into the plastic bag that Roberta left, and thus made the trash can empty in the cellar. And at 10:06 a.m., the Walsh daughter and the man she lives with blew their horn at Glendora 3 times when Glendora came out of the apartment to go to church on Christmas morning. After church, the women in the church asked Glendora to take a poinsettia plant to the Folsoms, Eleanor and Merrill Folsom. And we had never had time to celebrate their 72nd wedding anniversary, 72nd. So we celebrated them combined. It was 59 degrees on Christmas Day. Wasn't that beautiful? So combined, we celebrated their 72nd and our 40th, and that's 112 years of married life. At 3:30 p.m., Glendora picked up 4 Salem cigarette butts with lipstick at the front door where Roberta chucks them. Her lungs must be carbon black, full of soot. At 5:10 p.m., we did Walsh for the week, first the files. From 2:45 p.m. to 3:05 p.m., we wrote on grounds for eviction, Daniel, Roberta, and James Walsh. We wrote this to John Porzio. It's a big paper. At 4:49 p.m., we started typing 5 pages on grounds to evict. At 5:30 p.m., I paginated the wall file. It is up to 2,208 pages of law breaking. We typed 5 pages of convoy order to show cause to keep Glendora from informing the CEO of General Accident, Mr. Farnham, informing him of how the shareholders of General Accident are being ripped off by the COSA and Convoy and Odell conferences and depositions and minutes. We know, for instance, that the minutes cost $800. It's not fair that the shareholders should be ripped off. The next page in the wall log is 2,240, and we added up the torts, and the tortious acts were 1,421. And the time on wall the week of December the 19th was 21 hours. The cost was $7. So far as a record of what has happened on Glendora versus the law breaking of Roberta, Daniel, and James Walsh, and this is all grounds for eviction, of Nella and Theo Apulci, also grounds for eviction, and of Andrew and Kevin Larkin, who have moved, and of their lawbreakers, lawyers, Koza, Comboy, Odell, McGrath, Karamitsos, Bendish, and of the court, Carlucci and Wood. We're up to 1,421 tortious acts. This is Exhibit Eta Eta. This is mailing number 112, and it's page 2,241. At 9 p.m., Theo Alpucci drove the noisy Pontiac into our yard, and out of the yard under Glendora's south window. The car does not belong in this area. It belongs on the east side of buildings C and D. So we have air pollution and we have noise pollution. It costs $5.71 to print the wall log. It cost $2.07 to post it. It took an hour to do it, and it took a half an hour to distribute the other ones to the apartments. Daniel Walsh, Section 1542 of the criminal law. Daniel Walsh threatened to harm Glendora. That's part one. And Roberta Walsh actually did harm Glendora. So that's part one too. James Walsh did do Section 5 of the harassment law. 62 times 3 times plus 74 times 3 times equals 411 times. 4:30 p.m. to 4:52 p.m., 8 times Monday to 4:52 p.m., roller skated under Glendora's south bedroom window, and the 3 laws were broken 8 times, and that's 24 tortious acts. So Monday and Tuesday, breaking the law 700 times wasn't enough for James Walsh. He had to come back and do some more. On Monday. Well, on Monday I put up a curtain and I went on with my telephoning. It's important. The telephoning is critical. If you don't do it, everything falls apart. At 5 p.m. James Walsh went upstairs. At 5:03 p.m. everything was quiet. At 6:36 p.m. to 7:06 p.m. James Walsh roller skated underneath a south bedroom window, but he didn't bother with that much because the curtain was up there. I couldn't see him and he couldn't see me. But over into the northeast bedroom window, Franklin had the light on and he was typing, and James Walsh was over there most of the time. So it came out to 1,500 tortious acts. At 7:10 p.m. James Walsh went upstairs and the law breaking was over for now. Bad boy, bad boy, bad boy. What, as they say on Cops, sing on Cops, what you gonna do when? He was in the 3-car parking area more than under the south window because the south window was covered by curtain and the northeast windows were not. And James got as close to the light as he could, where he concluded we were and where he could do this evil breaking of 3 laws: harassment, noise, and disturbance. It's grounds for eviction. Let me read you part 1 and part 5 of the harassment. Section 1542 of the criminal law. A person is guilty of the offense of harassment when, with intent to harass, annoy, or alarm another person, 1. He strikes, shoves, kicks, or otherwise subjects him to physical contact. And then part 5 is, or he engages in a course of conduct or repeatedly commits acts which alarm or seriously annoy another person and which serve no legitimate person. And this, the Walshes, Alpucci's, have broken this law hundreds of times. December the 27th, 1994, Tuesday, 6:25 a.m. The hall and cellar were not clean last week. It's bad. The rubbish accumulation is disgusting. There's at least 8 feet high of rubbish. The place needs a superintendent. At 6:58 a.m., Nella Alpucci just drove her noisy Pontiac by our south bedroom window. Her car belongs on the east side of buildings C and D. Leaking exhaust, air pollution, and noise pollution. Tortious Acts 1503. What do you call a veterinarian who specializes in elephant skin disease? A pachydermatologist. Why do firemen always have a Dalmatian dog? So the dog can go ahead and find the fire hydrant. And did you hear about the little tailor who was impoverished and who was not making any money at all? And so the rabbi said, why don't you take the Lord as your partner? And the little tailor did. He took the Lord as his partner, and he did very, very well. And he said to the rabbi, you see that? Look, we got trucks all over the place. Look, there's a truck of ours over there. There's a truck coming. Oh, look, there's a truck right there. See it? Lord and Taylor. At 10:40 a.m., it was another beautiful weather day. Good weather since August. Sunshine, no wind, 50 degrees. At 10:54, Glendora took a package for Federal X from Bob to save Bob from going out there and getting it and save them from coming back here. I even set outdoors on the 28th day of December. Isn't that beautiful? When I came in at 1:30 p.m., James Walsh had come down the stairs from his apartment in his stocking feet and sat on the bottom steps and put his roller skates on. and he skated north on Greenridge. Okay, at 1:34 p.m. we wrote 15 minutes on the grounds for eviction of the Walsh clan and of the Alpucci clan. I did the writing for Tuesday and finished it, and then Frank typed pages 6, 7, and 8 this morning, and Glendora typed pages 9 and 10 to finish out the day's requirement. At 5 p.m. the Nella noisy car went out under the window, and at 6 p.m. The Nella noisy car came back, and you just heard a horn right then. That's at 12:46 p.m. on December the 29th, 1994, Thursday. Super VHS is terrific. Have you seen the programs on TCI with Super VHS? I was wearing a man-made furry vest, and honestly, the texture of that was so clear you could almost reach out and pet it. It is beautiful, Super VHS. To handwritten page 15 typed on the grounds for eviction of Walsh and Alpucci. And at 5:40 p.m. Wednesday night, the time we'd spent on Walsh was 2 hours and 40 minutes, and Theo Alpucci went by my south bedroom window, and my cats were in the window enjoying the beautiful temperatures, and Theo Alpucci mocked, "Meow, meow. Why can't he keep his big trap shut?" At 4 p.m., I went to the police to get a report, and there are no pages. It's pages 1 and 2, 1 and 2. He entirely left out my side of the story. He entirely left out my report of harassment by Roberta Walsh, pushing me, shoving me, slapping me, and throwing my cap, taking it off of my head and throwing it on the floor. What kind of a police officer is that? That's one offense of his. The second one is that he went to Walsh's first when we telephoned the police first. He should have come here first. And the third thing by Officer Glynn was that he says, "I won't come in to take the report. I'm standing out here in the hall." Unbelievable. There's a noisy truck that comes in here at 6 a.m. delivering the New York Times, I believe, and the driver goes way into the parking area. He leaves his radio running. He leaves the lights on, and then when he goes into gear, the gears make a stripping noise. And this is the fourth time that's happened. At 8:53 a.m. on Thursday this morning, I got up at 3 a.m. I wrote up to page 20 on grounds for eviction of Walsh and Alpucci, and then up to page 22, and I finished it. So it's up to date. The typing is behind. Enough of this dreary and dismal chronology. I have a mind of my own. Her mother-in-law says yes. Who else would like it? Piano tuner came to the door, and the housewife says, "But I didn't send for the piano tuner." And the man says, "No, but the people next door did." And have you heard about the four carpenters? Four carpenters formed a quartet, tubas, a tuba group. Four carpenters formed a tuba group, and they call themselves the Tuba Fours. Here is an outrageous, I would not want their bad record. And I'm talking about Wilson, Babe, Conboy, Koza, and Cousins. And it says, "Please find an order to show cause duly executed by Judge Harold Wood. As you can see, this is a temporary order which clearly and unequivocally prevents you from sending any further correspondence to any employee of General Accident Insurance Company until the determination of the order to show cause." So we have here Glendora plaintiff against Daniel Walsh, Roberta Walsh, James Walsh, Nella Alpucci, Theo Alpucci, Andrew Larkin, and Kevin Larkin, defendants, and index number is 20,483. That means this year so far, no, even beyond this, no, that was in 1993, 20,000 cases in the New York Supreme Court. If we didn't have so many lawbreakers, we wouldn't have so many cases. If people would live by the law and by the Golden Rule and by the Ten Commandments, we would not have 20,000 cases in the New York Supreme Court in 1993. Title of this paper is Glendora Shows Cause Why Her Freedom of Speech Should Not Be Gagged by the Judge Wood Court. Affidavit. Glendora, being duly sworn, deposes and says her reasons follow why her freedom of speech should not be gagged by the Judge Wood Court. Walter Farnham and any employee of General Accident Insurance Company are not a party to this action. Farnham, he's the CEO, and General Accident are not clients of Kevin Conboy, Koza, Karamitsos, Odell, McGrath, nor anybody else at Wilson, Bave, etc. Point 2. Ergo, the Judge Wood Court has no jurisdiction over Farnham and General Accident. This court cannot enjoin Glendora from contacting Farnham or General Accident. The arrogant imposition of enjoin and restraint upon Glendora, signed by Judge Wood December 19, 1994, is unconstitutional and as an arrogant and ignominious violation of due process. Glendora had no opportunity to be heard on this matter. Point 4. Further, the Judge Wood Court has violated Glendora's rights under the 5th and 14th Amendments of the Constitution of the United States of America. Point 5. Further, contacting Farnham or General Accident. The arrogant imposition of enjoin and restraint upon Glendora, signed by Judge Wood December 19, 1994, is unconstitutional and as an arrogant and ignominious violation of due process. Glendora had no opportunity to be heard on this matter. Point 4. Further, the Judge Wood Court has violated Glendora's rights under the 5th and 14th Amendments of the Constitution of the United States of America. Point 5. Further, the same violates Glendora's rights under the Constitution of the State of New York. There is no law that backs up this enjoin and restraint. Carefully listen to this, folks. There is no law that backs up this enjoin and restraint. In their usual nescience, the Wilson, Babe, Conboy, Koza, Odell gang quote the wrong law. CPLR 6311 applies to defendants, not to plaintiffs. It applies to defendants, not to plaintiffs. Look it up. Glendora is a plaintiff, not a defendant. And as points 1 and 2 state, Farnham and General Accident are not defendants. And CPLR 6311 applies to defendants. So Conboy has no grounds to make this order to show cause, nor does this court have any grounds to sign it. Point 9. It is well-established law that in order to obtain the drastic relief of a preliminary injunction, the movement, in this case, Kevin Conboy, must show by competent proof in evidentiary detail, 1, irreparable injury, absent the relief sought. In other words, how is Farnham and General Accident harmed by being told what the ripping off that Koza, Conboy, etc. are doing to the General Accident? 2, a likelihood of ultimate success upon the merits. 3, that the relief sought is favored by a balancing of the equities, Doe et al. Versus Axelrod. A failure to satisfy even one of these prerequisites defeats the entire application. Town of Southeast versus Canella and Bugler versus Walsh. The defendant have clearly failed to meet this strict standard. Therefore, the defendant's order to show cause seeking a preliminary injunction should be denied. Defendants have not shown irreparable injury. Defendants have not demonstrated likelihood of ultimate success upon the merits. Defendants have never dealt with the merits. Defendants have never dealt with a core, only with a penumbra, only to delay. The relief sought is not favored by a balancing of the equities. This court, in a dozen decisions, has not shown equity one single time. That's the Judge Wood court. As an example, Judge Wood allows certified mail to be good and sufficient service for Comboy's order to show cause, but for Glendora's 3 orders to show cause, Judge Wood insisted upon personal servants and stood by impotently as 75-year-old Franklin, a D-Day veteran, got beat up by Nella Alpucci, Theo Alpucci, and Roberta Walsh, and take all of the shrapnel of the White Plains Police, who failed to function as a Department of Public Safety. Conboy, like Odell and Kozer, fails to make one citation. The only law he quotes is CPLR 6311, and that does not apply to plaintiffs. Remember, Glendora, under the injury of more than 1,000 tortious acts by defendants, asked Judge Wood through 3 orders to show cause for relief, and Judge Wood denied all 3 of them, although the defendants never answered any of them. For the record, Walter E. Farnham's full address is 30 Sleepy Hollow Drive, Newton Square, Pennsylvania, 19073. To expose the injustice of the Judge Wood court manipulated by the Conboy gang, Glendora is sending a copy of her paper to Judge Kay, Judge Trafficante, Judge Malonis, Judge Ingrassia, and the Commission on Judicial Conduct. Further, the record will be reported on television. This terrified order to show cause by Conboy and the Wilson Babe gang and the Wilson Babe Frady cats, the Hollow Men, Glendora calls them, is blatant evidence that they know they are ripping off General Accident, that they have been caught at it, and that they are frantic to stop the leak by any crooked means they can find. All of this frenetic scrambling by Conboy and the Wilson Babe gang is highly valued by Glendora because it shows pellucidly she is right. She hit the hot spot. They are scared. They are running. They are scrambling to cover up. But it is all a public record in the courts and on TV. The secret is out. Kevin Conboy, like all the crooked Wilson Babe, Koza, Karamitsos, Odell, McGrath gang, does not declare under penalty of perjury. Judge Wood repeatedly lets this go. Conboy's rambling pleadings on the first page of his affidavit must be struck from the record as scandalous and prejudiced and untrue pursuant to CPLR 3024B, which he should read sometime. Kevin Conboy is not fully familiar with the facts and circumstances since he is not qualified. Here is another reason to reject his order to show cause. Conboy writes, Glendora alleges that she is entitled to money damages against 3 young boys and their parents because they have violated the White Plains noise ordinance, they have breached the quiet enjoyment of her home, and that they have negligently or intentionally inflicted emotional distress. Now, wait a second, Glendora says. This is not a statement of, quote, fully aware of the facts and circumstances, unquote. The facts and circumstances are, first, quote, 3 young boys, unquote, is chocolate-covered cyanide. For 3 obstreperous, undisciplined, captious, obnoxious, violent, law-breaking, injury-heaping, foul-mouthed, profane, obscene delinquents who have no respect for society, neighbors, adults, D-Day veterans, the United States of America, the sacrilege of the Star-Spangled Banner 3 times, nor for the state of New York, nor for the city of White Plains. Nor is Theo Alpucci a young boy. He is now old enough to be driving an automobile, turning it into a weapon of torts and obscenity. Conboy's list is short on the laws these delinquents have broken. Glendora lists the laws. 1, abusive, insulting, and humiliating language and disturbing utterances, profanity, and obscenity. 2, intent to annoy and alarm with no legitimate purpose. That's harassment, part 5. 3, intentional infliction of emotional disturbance with no physical effect. 4, extreme and outrageous conduct intentionally inflicted to cause severe emotional distress so extreme in degree, to go beyond all possible bounds of decency, and to be regarded as atrocious and utterly intolerable in a civilized society. 5. A deliberate, malicious, and vindictive campaign of same from April the 12th, 1993, Easter, to the present, Christmas 1994, 1 year and 8 months. And with full knowledge that emotional disturbance would result, violation of the White Plains Noise Ordinance, Glendora quotes from her complaint. What started this? The breaking of the law by the Walshaw, Pucci, and Larkin families, the White Plains Noise Ordinance, April the 11th, 1993, Easter. Quote, this is the White Plains Noise Ordinance. Yelling, shouting, hooting, whistling, and singing at any time or place, so as to annoy or disturb the quiet comfort, repose, health, or peace of persons in any dwelling or other residence. That is the law that was broken initially. When Glendora stood up for her rights and began videotaping her evidence, instead of reforming, said hoodlums started a long campaign of retaliation, more law-breaking, harassment, vandalism, thievery, abusive and insulting language, horn-blowing fright, mental disturbance, and littering. Not once on each law broken, but scores of times on each law. The total at present is 1,200 tortious acts heaped upon this plaintiff, for which the Judge Wood Court in 1 year and 1 month has done nothing to grant relief. Glendora would like to see Judge Wood or his law clerk, Carlucci, take even 1/10 of this abuse. What you just read above here on point 20 is an accurate statement of the gravamen. What Conboy wrote is, again, chocolate-covered cyanide. Now, the best thing Conboy can find to quote in law clerk Carlucci's sophomoric decision is this about the punctuation and about the spelling when these are nothing but logs. They are not legal papers, they're just exhibits. Okay. And we have Carlucci here who finds any excuse he can to rule in favor of the crooked Conboy, Koza, Odell, McGrath, Karamitsos group. It's, for instance, writing on both sides of the paper. Well, if anything, Judge Wood is a one-sided court. So that's, I guess, why they want all of the papers written on only one side, because Judge Wood is a one-side court. He rules only for the one side. Okay, to continue, this has to be struck from the record as scandalous and prejudicial, pursuant to CPR 3024B, both from the decision Carlucci made and from the instant order to show cause Conboy made. It reeks with malice and spite. It has no place in a legal paper, just as Carlucci has no place in the Westchester County Courthouse Tower. Glendora takes exception to Conboy's closing the spiteful, malicious quotation from Carlucci's bad decision of October 4th, 1994, when Carlucci should immediately recuse himself from her case because of his eye-blinding prejudice. Then Conboy, instead of dealing with irreparable harm and any sound reason for the order to show cause, tries to make a laundry list of Glendora's other fights for rights. Conboy has to do this because he cannot address his own cause on merits, because his cause has no merits. Judge Colabella is hardly a model to quote. If ever a judge should be discharged by the Commission on Judicial Conduct, it is he. He exceeds even the Judge Wood Court in spite, malice, and injustice. Glendora has seen Judge Colabella visit the scene of the murder, tamper with a witness telling him to say something that was not true when the jury came back, go back on his word, put his foot on the bench, leave the bench, jury and lawyers, to go talk to Glendora sitting in the gallery, bawl out a lawyer sitting in the gallery for rattling a paper. And so all of Conboy's irrelevant rambling of second paragraph is page 2 must be struck from the record by CPLR section 3024B. Just as the same prejudice, spite, and malice must be struck from Carlucci's sophomoric decision of October 4th, 1994. It is against CPLR Article 100 that the CPLR intent is conciseness. Conboy and Carlucci, of course, are too devious to mention Glendora's victories in their laundry list. Conboy says he is compelled to mention Glendora's litigiousness. Well, any such litigiousness is compelled by the law-breaking up to 1,200 tortious acts at the hands of such people as the defendants they are paid to lie about, and by the law breaking of themselves. General Accident is paying them for the cover. Not only are the lawsuits compelled by low-live tortfeasors, such as these 7 defendants in this instant case, but by the liars, thieves, cheaters, fugitives, and tortfeasors named as defendants in the rest of Glendora's fight for rights. And then there is the sludge coming from inept courts, arrogant law clerks, and corrupt judges. Here is a very well-written statement on same. Glendora found this in a wastebasket at a copy center. And that's that statement that I read you last week about bad judges. Where do you go when judges break the law? And I want to give you that telephone number to call. It's White Plains, 914-421-1200. Point 24, constant harassment, quote unquote, is a lie by Conboy. Harassment is intent to annoy or alarm with no legitimate purpose. Glendora has a legitimate purpose: to fight the crookedness of the Wilson Bave gang, who are ripping off the shareholders of General Accident and getting them a new CEO. Point 25, and here is another Conboy lie: harassment of individuals and business concerns who are not directly related to her pending lawsuit. Why are Farnham and General Accident not related to the pending lawsuit? When Koza, Conboy, McGrath, Karamitsos, and Odell are ripping them off with fees for conferences, papers, all of which are a public disgrace, depositions, and minutes. The minutes have cost shareholders $800 already. Glendora's lawsuit is not frivolous. Lawyers' defense is. Frivolous is another lie and must be struck pursuant to CPLR 3024B. Now, Conboy writes, Mr. Farnham himself made it crystal clear to your deponent's office that he did not wish to receive any further correspondence from Glendora at his home or his office. Glendora writes that apparently Mr. Farnham, instead of stopping the rip-off to shareholders, is going along with it. Conboy has no case when he childishly scribbles. No one should be subjected to such harassment at their family household. Glendora states that initially she sent the information to Farnham's office, but this was too easily shunted away from him. So the next step was to send it to 30 Sleepy Hollow Drive, Newton Square, Pennsylvania, 19073. It is not Glendora who spews poison, quote unquote. It is defendants Andrew Larkin, Kevin Larkin, Daniel Walsh, Roberta Walsh, James Walsh, Nella Alpucci, and Theo Alpucci. Conboy et al. Are not defending the action. They have no action to defend. Defendants have no defense. Defendants never will have. What Conboy et al., and apparently Farnham too, are doing is dollar-sucking the shareholders of General Accident. Conboy writes, she should not be permitted to annoy, upset, and harass any employee of an insurance company, and certainly not as chief executive officer at home. Glendora states, Conboy is not given one valid reason why Glendora's freedom of speech should be gagged. His paper is frivolous and a waste of scant judicial resources, quote unquote, made scanter by closing down the Westchester Supreme Court this whole week after Christmas, Monday through Friday. Did you know that the Westchester County Courthouse is closed down? Everybody's loafing. The courts are closed. And then that's why you wait. This case has been before a court for 1 year and a month, and nothing has happened. And so what's the solution? Close down for a week between Christmas and New Year's. All that Conboy writes is hysterics and histrionics, because he and the gang have been caught stealing from General Accident's cookie jar. Conboy writes to enjoin and restrain Glendora from serving any papers on General Accident. Glendora never did serve any papers on General Accident because, going back to point 1, General Accident is not a party to the action, and you can't serve them unless they're a party. At least Conboy enclosed as an exhibit a good legal paper. And that's my affidavit of Plaintiff Glendora to the lies of Kevin Odell in his November 28, 1994 reply affirmation. I sent that to Farnham. This is one lone plaintiff pro se fighting 7 law-breaking defendants and 8 law-breaking lawyers, a law clerk and a judge, and now a CEO who apparently does not want to know his shareholders to know they are being chiseled. At least Farnham knows he is paying for such good Odell grammar as, quote, has saw instead of has seen. And while we are at it, since they received no commission, General Accident has not paid Glendora her 2 witness fees of $15 each for the August 22, 1994 and October 23, 1994 depositions. When Glendora presented her 3 orders to show cause to Judge Wood, he took the teeth out of them, but he did not do the same to Conboy's. This December 19, 1994 paper by Conboy is just another reckless, irresponsible paper from the frenetic and evil law firm of Wilson Bave et al. It is like the sloppy, hurried answer, so-called, in the discovery demands they sent Glendora in January of 1994, after they defaulted in answering her summons in November 1993. Papers that had no application to the case at our bar, papers that said the verified answer of Larkin was enclosed and it never showed up until 2 months later. This is a crazy law firm. I guess they're all like this. Regard what Conboy wrote on his page 3. The plaintiff's personal dislike for a member of this court's staff is not a basis for this court's recusal. See, I asked Carlucci to recuse himself because he's obviously prejudiced. He's obviously up to here with spite and malice. And Carlucci writes, this court can and will continue to address this matter in a fair and unbiased fashion. That is a lie. To permit a litigant such as a plaintiff to control the determination of which justice will preside over a case based upon her personal dislike for a member of the court staff would be totally unacceptable. Well, Glendora says, delete plaintiff above and insert law clerk. And then you have this law clerk's personal dislike for the plaintiff. And down at the bottom you have wait a second. And based upon his personal dislike for the plaintiff. That's the way it really is. It is the law clerk's personal dislike of the plaintiff that is the truth. Law clerk Carlucci has been atrociously biased and unilateral in more than 4 instances with Glendora, and Judge Wood has added 4 more to that. Much more than 4. Say I can think of 3, and then 3 more. You know, it's more like a dozen. And recall that it was Conboy who violated CPR 3101F and refused to turn over the insurance agreement to Glendora when requested. Now it becomes clear why. He didn't want Glendora to find out the truth, that general accident policy does not cover Larkin for non-bodily injury, nor for intentionally inflicted injury. And remember, the Larkin defendants clearly defaulted. Their answer was due December the 1st, 1993. They did not answer until January the 6th, 1994. That was another Carlucci decision against Glendora, which is on the record. That's a default as anything clear as could be. To deny Glendora default judgment is an injustice that will long live in Judge Wood's record. Glendora fully expects law clerk Carlucci to comply with the CPLR and justice. And Glendora reminds the Judge Wood Court of CPLR 3026. Pleadings shall be liberally construed, defects shall be ignored if a substantial right of a party is not prejudiced. I've done nothing about my rights. Nothing at all. If Judge Wood signs his gag order, then he and Carlucci and the whole Conboy-Kozer gang are open for United States District Court, Southern District, White Plains, New York, Title 47, United States Code 1983, which says if you violate the rights of a citizen of the United States, you are liable under color of state. And this is certainly under color of state. Glendora is going to add the New York State Commissioner of Insurance to the list to receive a copy of his affidavit. Wherefore, for all the reasons stated, pages 1 through 16, plaintiff Glendora has shown cause why her freedom of speech should not be gagged and pleads that this court deny defendant's illegal and frivolous order to show cause of December 19, 1994, and Glendora further asks for whatever other and further release this court deems proper and just. That's a laugh for this court. Dated White Plains, New York, January 6, 1995. Yours in truth, Glendora. Subscribed and sworn to before me. This 6th day of January 1995 to Kevin Conboy, Wilson Bave et al., 2 William Street, White Plains, Judge K, that's Chief Judge K, Judge Trafficante, Judge Malonis, Judge Ingrassi, and the New York State Commissioner of Insurance. And I think I will also send a copy of this to Evans Brewster. Pleadings. Miscellaneous. Defects in pleadings should not defeat otherwise meritorious claims. You hear that, Carlucci? Defects in pleadings should not affect otherwise meritorious claims. Here again is that picture of Judge Colabella visiting the murder scene when he is the he's the person who's going to decide the case, and he shouldn't be visiting the scene of the crime, along with many other things that I mentioned he did in here. Okay, enough of that, and now we are going to have some jokes. And a pianist was asked, why did you choose? The pianist thought a long time. He says, I think it's because that's what the orchestra was playing. And did you hear the news headline on TV that a freighter carrying a load of yo-yos struck a reef off the coast of Florida and sank 42 times? And here's another one. A ship, a freighter carrying a load of red paint collided with a freighter carrying a load of purple paint, and at last reports, the crew and passengers of both ships were marooned. Okay, this is from Glendora on December the 28th, 1994. To John Porzio, the owner of 21 Greenridge Avenue, White Plains, New York, 10605, 914-428-6181. Dear John Porzio, December 19th, 1994, Monday at 6:30 p.m. to 7:30 p.m., James Walsh roller skated past our south bedroom window 62 times. He would go to the southwest corner of the apartment, turn around, skate past very close to the window as far as the southeast corner of our apartment, turn around and go by our window again. We have this on videotape and audio tape. This was on his part intentional infliction of emotional disturbance with no physical effect. This was on his part a malicious campaign to annoy and disturb with no legitimate purpose, i.e. Part 5 of the criminal harassment law. This was on his part a willful violation of the White Plains noise ordinance. Noise that annoys or disturbs the peace, quiet, repose, health, comfort, or persons in any dwelling or residence at any time or place. This is 62 times by 3 laws equals 186 tortious acts. This is grounds for eviction. By the real property law, section 235, a landlord cannot willfully and intentionally interfere with a tenant's quiet enjoyment, also known as peaceful possession of premises. When you allow the Walshes to inflict disturbance 186 times on us and do not evict the Walshes, you are willfully and intentionally interfering with real property law, section 835. The penalty is a criminal violation. Here's a case of passive negligence. Right here, folks. This case right here is passive negligence. Passive negligence on the part of the wrongdoer to one guilty of passive negligence. On the next night, December the 20th, 1994, 5:25 p.m. to 6:22 p.m., James Walsh started his disturbance, harassment, and noise and passed under our south window 74 times. 74 times 3 equal 222 tortious acts against us. This is grounds for eviction of Daniel, Roberta, and James Walsh. There are plenty of places to roller skate. His roller skating under our window was intentional, deliberate, and malicious disturbance, noise, and harassment. At 6:22 p.m., James Walsh fell prostrate on the asphalt. He screamed a lie to his mother and father, who were in apartment 3A. She pushed me. Daniel Walsh lies, Roberta Walsh lies, so why wouldn't James Walsh? At 6:22 p.m., Glendora was coming through the front door of Building A as Daniel Walsh was exiting by the front door. He was simian, truculent, and threatening. Glendora was frightened by him. She moved as fast as she could by him up the stairs to go into her apartment. Daniel Walsh says, "You'd better run to your apartment." This is grounds for eviction of Daniel, Roberta, and James Walsh. Just after Daniel Walsh orally threatened Glendora, Roberta, who was coming down the stairs from the second floor, reached the landing where Glendora was standing by her door. Roberta Walsh pushed Glendora, shoved Glendora, slapped Glendora in the head, grabbed Glendora's red knitted cap from Glendora's head and threw the cap on the hall floor. This is grounds for eviction of Daniel, Roberta, and James Walsh. By real property law, Section 235B, the warranty of habitability, Glendora has a right to be free from conditions endangering her or detrimental to her life, health, and safety. The violation by Roberta Walsh is a violation of the warranty of habitability that John Porzio owes Glendora by state law. Statutory rights of tenants. Right to habitable premises. Warranty of habitability. Landlord, in every written or oral residential lease, please remember this, folks, this is your right. Whether it's written, whether it's oral, whether it's said or not even mentioned, it's still there. It's a statute. Our landlord in every written or oral residential lease warrants that the premises and common areas are and will be maintained in a condition that is A, fit for human habitation, B, fit for uses reasonably intended by the parties, C, free from conditions endangering or detrimental to life, health, or safety of occupants. Tenant cannot waive or modify this right. Tenant can prove damages for breach without expert testimony. We were, until 7:27 p.m., reporting this to the police and cleaning up after it. That is 2 hours times 2 people.